You are listening to an Eyes on Washington podcast brought to you by Holland and Knight's Public Policy and Regulation Group. Our Public Policy and Regulation Group is a strong bipartisan team with deep ties throughout Washington, D.C. We have built a thriving government affairs practice through our depth of experience and diversity and by maintaining our bipartisan approach. Our State Attorneys General podcast series is hosted by former Deputy Attorney General of Virginia and presidential appointee at the U.S. Department of Commerce, Stephen Cobb. Through conversations with State Attorneys General, this series will dive into the importance and growing role of State Attorneys General while hearing firsthand on what they are working to accomplish in their communities.
Welcome to another installment of Holland and Knight's Eyes on Washington podcast, State Attorneys General Edition. My name is Stephen Cobb. I'm a partner in our Washington, D.C. office and former Deputy Attorney General of the Commonwealth of Virginia. I'm very excited to have not one, not two, but three of my colleagues on the podcast today as we talk about the important role that Governor's Counsel plays in both policy formulation and regulatory enforcement across the United States. And so I'm very lucky that I have three colleagues who served as counsel to the governor in their respective states. So we have Chris Riano, Jim Schultz, and Robert Highsmith coming from the great states of New York, Commonwealth of Pennsylvania, and Georgia. Gentlemen, welcome to the podcast.
Thanks, Steve. Thanks for having us.
Yeah, thanks, Steve.
Thanks for having us.
So let's get started. Chris, I want to start with you. Let's talk a little bit about, very briefly, your career trajectory, how it got you to the governor's office, and some of the kind of overarching roles and responsibilities that you had while serving in the counsel's office to the governor of New York. And then Jim, Robert, if you can do the same. One of the interesting things here that I think we're going to highlight is that each office is a little bit different, and the issues that you touch on and the powers that you have vary from state to state, which really impacts the private sector's knowledge and ability of when and how to interact with those offices. So Chris, start us off.
No, Steve, I so appreciate that. I think, I had the fortunate opportunity to kind of go backwards from what most people get to do. And as opposed to going from the central executive staff as an assistant counsel to the governor into an agency, I went backwards where I was the general counsel of the New York State Liquor Authority before becoming the assistant counsel for education and constitutional law for the governor of New York. And I think one of the things that is very unique about at least the processes here that we have in New York, and I know that not every state's like this, but at least here, it's a pretty top-down structure. Right under the governor are two statutory offices, and only two. There's the secretary to the governor, who handles all of the political questions that may come up. And there's counsel to the governor that handles all of the legal questions that come up. And that flows all the way down into every state agency. So each counsel has a portfolio of general counsels that report to them, which then have a portfolio of lawyers in each agency that report to them. And it's a very unique structure. But what it really allows for, at least in the New York model, is for an incredible opportunity to have an influence, particularly when it comes to the enforcement of regulation. So at the State Liquor Authority, I was in charge of regulating all alcohol in the state of New York. The buck really did stop with me. As assistant counsel to the governor for education, I was in charge of making sure that the laws and regulations of the state managed the $40 billion education budget, almost a third of the state budget of New York. And that includes writing legislation, that includes editing legislation, that includes writing regulation, approving regulations for all the agencies that report to you. It's an incredible opportunity to really have a very big impact on the state, and especially in a state that has as large of an influence as the state of New York does within both the state level and the locality level. You really do have this opportunity to have a massive and impactful difference in a way that's very, very unique as an attorney.
Now, Jim, that sounds slightly similar to what I understand the formatting is in Pennsylvania as well, as the counsel to the governor largely sitting in a general counsel role to departments and agencies. Are there parallels there?
There are some parallels, Stephen. In Pennsylvania, it's unique. By statute, the general counsel is appointed by the governor and is general counsel not only to the governor, but to the Commonwealth of Pennsylvania. So your title is general counsel to the Commonwealth. And why that's important is because you oversee the legal operation for 37 state and independent agencies. So for instance, even the state system of higher education, which is 14 higher educational institutions in Pennsylvania, is a separate board. The board is appointed by the legislative bodies and by the governor. The general counsel to the governor oversees the chief counsel's office to the Department of Higher Education. Similarly, with state agencies like Department of Transportation, Department of Environmental Protection, Department of Human Services, those chief counsels are also appointed by the general counsel to the Commonwealth and are sole appointments by the general counsel of the Commonwealth. So essentially, the secretary of the Department of Environmental Protection is counseled by a lawyer that's appointed by the general counsel to the Commonwealth. And that gives tremendous oversight opportunity and a top-down oversight opportunity for the governor's office. And we're also involved in the regulatory review process at the agency level, and then ultimately has to be signed off on by the general counsel. So there's tremendous power and authority in statute for the general counsel by and through the regulatory review process as well. So other things the general counsel does is review the death penalty cases where the governor has to sign off on death warrants. That's something general counsel performs a review on. Pardons is another one that the general counsel's office provides some review on. There's a lot of issues that come up through many of the independent state agencies. For instance, when I was there, those pension systems were also counseled by the governor's office of general counsel. So they were really the lawyer for the state. And the interplay with the AG's office was a little different. So, for instance, if a state agency was sued by an outside entity, the right of first refusal would go to the AG's office to handle the litigation. But in the instance where the general counsel's office might differ from the AG's office in terms of policy, the general counsel's office could take that case back and handle it themselves or assign it to their own outside counsel to handle.
That is very interesting. I mean, in Virginia, all of both Chris and Jim, the responsibilities that you talked about and the oversight for those agencies is all held within the Virginia Attorney General's office. And so it can create those very interesting dynamics at times with the governor's office, particularly when they are of different parties. But there is no statutory creation of counsel to the governor in Virginia. It is at the pleasure of the governor. So much like they might have a deputy chief of staff or a senior advisor, but the role is sometimes they make it cabinet level through an executive order, and other times they don't. But so it can really vary administration to administration. Robert, talk to me a little bit about the counsel to the governor in Georgia. Where does that fall kind of in the scheme of things with New York and Pennsylvania on one end of the spectrum and Virginia on the other? Where does Georgia fall?
Thanks, Stephen. It's really more closer to the Virginia model. In Georgia, there is a statute that specifically authorizes the governor to hire executive counsel. The statute's been on the books for decades, and governors for decades have employed between 2 and 5 lawyers in their offices to report directly to them and advise them on the whole gamut of executive branch legal matters. When I was in Governor Sonny Perdue's office, there were 2 of us, Harold Melton and me. Harold would go on to become Chief Justice of our Supreme Court here in Georgia, a role from which he only recently stepped down to rejoin private practice. We don't have the formal level of oversight that Jim was describing, but it's very much an informal level. That is to say, most of the agency heads in Georgia are appointed and serve at the pleasure of the governor. A few of them have terms, and most of them have some sort of board that ratifies their appointment. But practically speaking, the governor hires and fires executive agency heads. And governor's counsel or the executive counsel to the governor will frequently be the ones that lawyers embedded in those agencies will call and say, we've got this issue. What would the governor like us to do? So even though it's not a formal supervisory or oversight role embedded in statute, it nonetheless is one where you're the lawyer in state government that all these agencies are calling to determine, how they should handle a particular problem. We differ from Virginia and most states in that in Georgia, the governor has absolutely no powers of executive clemency. All of the executive clemency powers are reserved to a constitutionally established board of pardons and paroles. And so I remember on the first day in office, the governor's green new chief of staff wanted to know where the red phone was where the calls would come in from the prison in Jackson. And we didn't have that at all, which frankly suited me fine.
I'm sure that wasn't an awkward conversation at all, though.
I think he might have been looking forward to it. I certainly wasn't. But that was, so again, no executive clemency powers. And then you have the Attorney General in Georgia. The Attorney General is an elected position. And the Attorney General provides, by Constitution and statute, provides representation to the agencies so that if there's litigation or advice that the agencies seek from the Attorney General, then the Attorney General and the state law department provides that advice. And that can create friction. I mean, in the first year of divided government, when I served as executive counsel, in Sonny Perdue's office, we sued the Attorney General 17 days into the administration because there was a tug of war over who got to set the direction in some litigation the state was involved in concerning redistricting. And the Democratic elected Attorney General wanted to pursue it. The governor wanted him to drop it. The Attorney General refused. And so off we went. That case, we ended up losing that case. That case ended up setting some of the parameters around what legal powers the governor has to direct the legal affairs of the state and what powers the Attorney General has. I would say, though, Stephen, that even then, even when we were fighting hammer and tongs over something as politically volatile as redistricting, the Attorney General's office and the governor's office work together hand in glove and get along, no matter where they come from, what party they come from, on, I would say, 90 to 95% of the issues. It's a very professional, working relationship, almost because it has to be. But occasionally the big, and since 2006, we've had governors and attorneys general of the same party, and that has limited the amount of friction between those offices in Georgia.
Building on that, I had the same experience. So in addition to just litigation issues, every contract, every procurement that comes through the Commonwealth has to go through what's called a formal legality review process in Pennsylvania, which involves a sign-off by the agency counsel, a sign-off by the Office of General Counsel of the Commonwealth, but also a sign-off by the Office of Attorney General. So whether it's litigation or contract review, there's always this interplay and back and forth between the Office of Attorney General and the Office of the General Counsel of the Commonwealth.
That's an excellent point, and it also leads to a good segue. I mean, I know you all are regular monthly listeners to this podcast, so this will come as no surprise at all. But one of the things that I have talked about with all of our guests over the last year or so is kind of my underlying thesis, which is that states at this point really are the driving force for both policy and regulatory enforcement across the country. I talk about the tens, if not hundreds of billions of dollars over the last 20 years that state AGs have collected in the form of fine settlements and judgments, but also as a matter of, to borrow the Clinton-esque adjective, the laboratories of democracy that are the states for when it comes to pushing forward what is the new public policy agenda across the country. So comment a little bit, if you can, about, kind of where you see states as driving forces in comparison to their federal counterparts on the policy and regulatory enforcement space. Chris, let's start with you.
Sure. I mean, in so many ways, there's no question in my mind that as important as the federal regulatory space is and federal enforcement is, and it most certainly is very, very important. The state, at least especially in the state of New York, the state AG, state agencies, and especially throughout the state budget process, there's no doubt in my mind at all that there's an incredible amount of power vested in the various different bodies that exist within the state, both to create regulation and to enforce regulation. That can be inside an agency, that can be internal to an agency when a particular agency is created to be a regulatory body. And that can be with the state AG's office. And we have a famously engaged Attorney General's office. In fact, in New York, we always call, and we have a moniker for the AG, we call them the aspiring governor, because we have such an engaged Attorney General's office. And, to one of the points that was brought up earlier, it's interesting because sometimes there can be a little bit of tension. That does come up. You have independently elected officials. Here we have four: the governor, the lieutenant governor, the attorney general, and the comptroller. And there can be the tension between those independent statewide offices. I know the vast majority of state agencies use the AG's office for litigation. And I was fortunate, or maybe just had a very unique experience in that we did not use the AG's office for litigation. We self-litigated at the State Liquor Authority, which made for a really interesting experience being the chief lawyer at that agency, especially since we did not hire outside counsel. We just litigated ourselves. And so I think in so many ways, it's why it becomes really important to understand the state itself. Because, Stephen, to your point, States are that laboratory, and states do have an incredible amount of authority, dominion, and control, particularly since so much money, so much money, whether it's health money, education money, or other forms of money, flows through states, even when it comes from the federal government, flows through states to localities, and therefore states have an incredible amount of authority over how that might get spent, and then the ability to investigate when there's problems that come up in those various different areas.
Robert, give me your 2 cents here, because in particular, I know Georgia really considers itself a driver here in best practices. And, I've heard AG Carr talk about the environment that they're trying to build in Georgia as a driving force for economic growth. But whether that's economic growth or like what Chris was talking about, regulatory enforcement, states seem to be tip of the spear. What are your thoughts?
Sure, Stephen. In Georgia, the Attorney General's office, again, as we've discussed, handles very nearly all of the litigation that the state's involved in. And whenever there's a major settlement with an industry on, whether it's tobacco with the Master Settlement Agreement or the opioid settlements that are coming down now, the Attorney General's office oversees those, but honestly has to share a lot of the duties with the governor's office and legislature in terms of how those funds will be spent. Frequently, there's accompanying legislation when there's a major settlement, so the Attorney General doesn't have just plenary authority on how those funds are spent. The major policy decisions and policy direction, though, is really set by the governor's office. Those are, they'll consult with the Attorney General, where there are legal issues, but all of the legislative review and it's rare for the Attorney General to have a major influence in significant legislation. They'll be consulted, here and there. But it's really the governor's office that drives those processes. Now, one thing that has moved away from the governor's office in recent years and into the Attorney General's office is consumer protection. For decades, we had the governor's office of consumer protection that had lawyers in the office and a director that reported directly to the governor, and they're the ones that went around, engaging in consumer protection litigation, et cetera. That has recently been moved under the Attorney General the way it is in many other states, and the Attorney General's office now has primary enforcement and litigation authority for consumer protection matters. And, states have been, as we all know, working in this space, states have been pretty active in that regard. But in terms of the major policy initiatives, our Attorney General, who you mentioned, Stephen, Chris Carr, is going to work hand in glove with his ticket mate and party mate. They came into office at the same time, almost, and they're going to work very closely on policy issues, but it's really the governor's office that drives it.
So, Jim, looking into your crystal ball here, whether it's governor's offices, AG offices, what do you see as the hot policy / legal issues that are going to be dominant over the next, whether that's 6 months, 18 months? Where do you see those driving issues percolating up from the state level?
So I'm going to talk a little bit about the Pennsylvania on this topic, because Pennsylvania is kind of ground zero for natural gas and Marcellus shale. And you have this constant, push and pull over pipelines. You have a constant push and pull on how to, get through zoning to get the pipelines across the state to move the oil and gas. You have philosophical differences between the last administration in the state and this current administration who's on his way out, and then a sitting attorney general who's now running for governor. And, there has to be this balance, and the governor's office and the Department of Environmental Protection really sets the policies that, as it relates to environmental issues and energy, if you will. And then the Office of Attorney General really only gets involved in civil enforcement and criminal enforcement should folks cross the line. And we've seen, General Shapiro bringing cases against Energy Transfer in a criminal capacity recently. And we've also seen, prior attorney generals take on other entities in the same way. And, sometimes they're at odds with the department in terms of the governor's administration. Even if they're on the same side of the aisle, they might not necessarily agree as to what's appropriate and what's not, and what's in the best interest of the Commonwealth and what's not. And that's just an interesting push and pull to see, and very important that the legislature, also step in and has its role as it relates to regulating these industries as well, because you have the balance that you're striking between, the need for energy independence and then the need to make sure you're protecting the environment. And in Pennsylvania, we actually have an environmental rights amendment.
That's an excellent point. And it also includes that kind of dichotomy, which is when are you working, particularly in states like New York and Pennsylvania, and when are you working with agency counsel that goes to regulatory compliance, and when are you working with an AG's office, which is civil enforcement? And sometimes those lines can be really blurred. But in order for companies to really be able to have effective and productive business models, kind of understanding that push and pull between the two, I think can be a really important factor in the success of their business and ensuring their regulatory compliance moving forward. Robert, and I think, Georgia having that interesting change that you mentioned of moving consumer from kind of one side of the divide to the other provides an interesting foil for that. But what are some of the areas, pivoting here just a little bit as we talk about how do we work within the regulatory paradigm that varies from state to state? When are you working with the governor's counsel's office? When are you working with a general counsel to a agency? When are you working with an AG's office? When do you reach out? What are some best practices, tips and tricks that you've noticed over the year that has really helped private sector engage in a productive manner as part of that regulatory overlay in order to make sure that they are able to continue to grow and do their business, but at the same time remain compliant?
Sure. You just have to know who in these various pockets of lawyering is in charge of what issue. For example, it's very helpful to know if you're dealing with a utility regulatory issue that the AG's office actually is heavily involved in that, because there's a longtime senior assistant attorney general who not only advises the Public Service Commission, but also litigates before and on behalf of the commission. And it's been the same guy for 20 years, Dan Walsh. And you're going to talk to him if you're dealing with utility regulation. If it's a consumer protection issue, the longtime head of that office, both when it was under the governor and now that it's under the attorney general's office and Infinger, is a longtime lawyer there who you're going to want to talk to. If it's a legislative issue, you would want to start with David Dove, who's the executive counsel to Governor Kemp and has held that role since Governor Kemp took office. And one function, by the way, that I should have mentioned is that all of the legislative review before the governor signs anything flows through that office, the Office of Executive Counsel. They're the ones that review all the legislation, the several hundred bills that the Georgia General Assembly will pass in any given session, and advise the governor on which ones to sign and which ones to veto. They also vet and frequently draft the governor's legislative package. So if you have an issue that you hope to have the governor champion through the legislative process, that's going to be the governor's counsel. In the agencies, though, if you're dealing with a procurement issue, you have the Department of Administrative Services that has, and its general counsel, by the way, was a longtime general counsel, was just promoted to commissioner. She's now running the agency. She actually, Rebecca Sullivan is her name. She succeeded me as in the role of executive counsel to Governor Perdue. And that office is going to handle the mechanics of procurement, but in a pre-procurement, when the RFP is being thought about or considered, the agency counsel is going to have a heavy role in designing that RFP and pushing out the end user specifications that the DOAS will then release. So, each of these, it's different in each state, as we know, and in Georgia in particular, it's important to know, which of these, little mini law firms that serve state government, what's in each of their wheelhouses, so you know who to call. And it can be agency counsel, it can be the governor's counsel, it can be the attorney general's office, and it's going to vary, with issue and with agency according to what it is you're trying to achieve for your client.
And Chris, I imagine you come across that a lot, not just from the work that you did inside government in New York, but as part of that national regulatory practice as well.
Absolutely, Stephen. And I think something that was just mentioned that's really important is legislation and the incredible role that frequently both agency counsel, but especially governor's councils have in legislation. And whether that's negotiating the legislation ahead of time to make sure that it's something that will be signed, or in New York, we have a very unique structure where we actually can negotiate amendments to legislation after it's been passed. And that can actually become part of the negotiated package called a chapter amendment. And that's all the councils. That's a huge part of your portfolio, is deciding what gets signed, what gets vetoed, making those recommendations, making amendments to see if you can get the veto rate down and get more things signed by amending legislation that's already been passed. And that's just on the normal legislative cycle. The budget itself is written in tandem with the budget division by counsel's office, because there's so many different policy initiatives that end up being put in the budget because of the way that the state constitution works in New York. But that's actually not too rare that that's where a lot of that resides. And that is a humongous role, because legislation, of course, drives policy. And it's a small number of people in every single state that have that opportunity to make those, not just recommendations, but often decisions on legislation that can have a massive impact on industry.
That's an excellent point. Gentlemen, as you can see, I could probably talk about state regulatory do's and don'ts and ins and outs for hours and hours. But unfortunately, we do only have a limited amount of time. So first, Chris, Robert, Jim, thank you for your service as counsel in your respective states of New York, Georgia, and Pennsylvania. And we're lucky to have you as part of our team here at Holland and Knight. So before we sign off, is there any other final parting thoughts or bits of wisdom that you'd like to add? I'd like to give each of you just a moment or two, if you have any parting comments.
I think Robert summed it up very well. It doesn't matter if you're talking about a government procurement, government tax incentive, government grant, legislative priority, or regulatory priority. All of those issues are centrally located in the governor's office, and more particularly in the governor's offices of counsel, and they have a unique ability to impact those issues. And it's very important that you also have a good relationship and understand the inner workings between the governor's counsel and the AG's office in order to accomplish those goals. So I appreciate all of our listeners out there hearing us out. And if you have those kinds of issues, please give us a call.
I can't improve on that, Jim.
Yeah, Jim, that was so well said. I think you're exactly right. And I think it's one of those interesting parts of having had a chance to serve in government that we've all had a chance to see that at that level.
On that note, thanks again, gentlemen, for joining the podcast. This has been Holland and Knight's Eyes on Washington podcast, State Attorneys General Edition, as we talked about the role of Governor's Counsel. I hope you all will tune in to the next installment. Thanks so much.
Thank you for listening to an Eyes on Washington podcast, brought to you by Holland and Knight's Public Policy and Regulation Group. For more information on our Public Policy and Regulation Group, please visit hklaw.com/ppr.